It's got to be good, and even if it is good, still finding somebody that say, I'll try
It's
that.
February 13th, 2012.
I've been buying the on sale stuff.
Time is
You know,
6:32
I go to
p.m.
Market Basket, and all the microbreweries have a different sale every week.
Tom Walton.
Oh, I'm sorry.
Here.
Beg your pardon.
Steve Machowski.
Here.
Ed Nason.
Not here.
Gary Ciccarone.
Here.
Rick Charette. Jim Freeman.
Here.
Clifton Camp. Charlie Coleman. Ron Collins.
Here.
Ed Comeau.
Here.
Okay,
We have an alternate.
Alternate, ex officio alternate?
Yes, we do. You're still, right?
Still.
Right. Please note that Rich is here and,
Let's get them walk.
oh,
Sorry,
well,
Rick.
late attendant. Just moments. He's here.
Brewery talk.
I was just gonna say, does it look on?
Brewery
Probably
talk.
the safest one on the whole row.
What's your normal seat?
That one won't fall
I
apart.
wouldn't take your seat from you.
Well, it's not my seat, man. Anything goes. Fat guys do like bigger seats.
No comment.
I said it, you don't have to.
Are we all set?
if you wanted to, we could also.
Oh, we need one more.
Yes.
Oh, no, we don't.
Oh, finally, the late guy's here. Is my car still smoking out there?
I don't know, but the tires for the trail all the way down the mountain still wet.
All set, George?
Yes.
Okay. First thing to note is if you have the agenda, there's an accidental misprint on it. It says public hearing. There's no public hearing today. Okay, so we've had our call to order, our roll call. Announcements, correspondence, and mail. Fun. Okay, first thing, we received this February 2nd from PSNH. It is a courtesy letter notifying us that a lot of you probably got notices in the mail that they're going around to trim the trees to make sure the power lines don't get wrecked. This courtesy letter describes probably about 24 trees that they've identified that are on scenic roads, particularly Moose Mountain Road, Tumbledown Dick Road, Lyford Road. And these approximately 24 trees require, because they're bigger than 6 inches, they require a hearing for us to review before they get sent to the axe. So we'll address that later in the meeting, but here's the courtesy letter if you want to see it.
Some of my trees only have 6 leaves left on them.
Yeah. Okay, other things. We've got the latest Town and City, always fun reading. Please enjoy. This is something interesting that I was just reading, and I guess I can read it, although it seems a little interesting. It is from Mitchell Municipal Group, which is our law firm that we retain for the board. And it says, January 5th, 2012, notice of Supreme Court decision, Entiger versus Town of Madison regarding right-to-know law. On December 8th, 2011, New Hampshire Supreme Court issued a decision regarding the right-to-know law, RSA 91-A, which affects all of our clients. The court held that boards may not meet behind closed doors to discuss the advice of their attorney unless the attorney is present or available for a contemporaneous exchange of words and ideas by, for example, being on a speakerphone. This decision is contrary to the advice generally given over the years that the consultation with counsel exception to the right-to-know law allowed boards to meet and discuss legal advice even if the attorney was not present, as long as the discussion was limited to that advice. In light of this decision, boards should not discuss letters or emails from or telephone conversations with their attorney unless the attorney is present, either in public or on the telephone, or the conversation falls within...
In person or on the telephone?
I'm sorry, I guess I didn't read that very well. Let me reread that.
Yeah, it's different.
In light of this decision, boards should not discuss letters or emails from or telephone conversations with their attorney unless that attorney is present, either in person or on the telephone. So they're saying the attorney has to be in communication with the board when you're discussing whatever this advice is, either by telephone communication or actually in person. While we recognize the increased burden that this places on towns, unless and until the legislature amends the law to allow such discussions, any such conversations would be a clear violation of the law that could result in a court awarding attorney's fees to any citizen who brings a lawsuit to challenge such discussions. As always, should you have any questions or concerns about this decision, please do not hesitate to contact us to discuss it further. And it's undersigned by the 4 attorneys in the group. It sounds to me that the way this is written is that we can't discuss our attorney's advice in the meetings anymore without having them on the phone, which is $250 an hour, something like that. Yeah, I think somebody's jacking up the bills. Yes, Rob?
Is it only that we can only do that, we can only go into what, the executive session or whatever it's called? Does this apply only to non-public discussions of their advice, or because you just, if it's public discussions as well, you just violated it, right?
Well, no, this is just advice.
Yeah, Rob's got it.
That's a letter from our attorney, right?
Cuffs, please. Yeah.
I remember when we did the site plan review, that you could discuss the attorney's counsel in public because it's an open forum, no matter what. The only reason we didn't want to do that is because it was such a precarious situation where a town selectman was suing the board, and if we had to open discussion, then I guess you'd play tip your hand or some other weird thing, you know. But that's,
well, I guess the whole thing's changed now. This decision's come out.
Well, is this all related to right to know? In which case, public hearing. I mean, the whole idea of the right to know is that it should be done in public. So,
right.
If that's the case, I would assume that means that we're fine discussing in this forum, in a public hearing, a public meeting.
Yep.
That we're okay discussing letters to and from the attorney, their advice, and so on.
So long as they're on the phone.
No, I think that's if it's right to know, then that's all about making sure everything is done available to the public.
Right.
And there's very few exceptions where you can avoid the public being present and being able to see the minutes, you know, and within 5 days and all that. I think that if they cite the right to know RSA, then that has to only apply to non-public meetings.
that's what that letter says.
Yeah, my first reading of that.
Non-public discussion of attorney advice.
Right. My first read through that just now made me think one way, but now I'm suddenly flipping back the other. It sounded to me the first time that it was the opposite, that you had to have them on the phone at all times. That's what the second paragraph seemed to say, is that they are advising us that they want to be involved in any conversation. But the first half of the letter talked about how there was the court decision that we couldn't meet behind closed doors using 91A to discuss legal advice anymore without the attorney being involved. Sorry.
Well, Colin, we pay for the advice, and once we get it, we should be able to use it.
I think they're concerned mostly on our interpretation of their advice without having any input in it. It might go off in a different direction.
Well, I've seen several times when we've had their advice, and when something was left to interpretation, we always went back to them.
Right. But this would sort of short circuit having to recall them or get in touch with them again at another meeting or whatever. And I think it's that, you know, cover your ass type of thing is coming up.
It's a form letter
for their end of it.
Yeah.
I don't like the idea of them continuously having a meter running.
Yeah.
They can't require us to not discuss their advice to the board without them present. They can't require that legally, but they can require, the court is requiring us to discuss it only in an open forum. That's all that letter states. So we can't do any more closed meetings, which we always did, so that we wouldn't have the public hearing what the lawyer advised us for whatever reason.
Yes, Jim.
We did meet, when we did talk with the lawyer, no discussion was made after that point, to my knowledge, by any quorum of this board, for any discussions that we had with the lawyer. Any discussions beyond that point were brought up in public forum. And
We had closed meetings.
Yeah, we had closed meetings with the lawyer.
No, without the lawyer.
Yeah, but it all doesn't matter because it was all before December 8th, 2011.
Yeah, right.
The decision was made December 8th. Yes.
Much like Rick said, we pay for that attorney, why don't you call and ask her? Ask her to clarify it, I mean, you know, ask her. Understand.
It's $50 after 6 o'clock at night for 5
Well,
minutes.
no, I don't mean now.
I suppose between now and the next meeting, we could get the answer.
Yeah, I mean, it sounds to me like the way I hear it has nothing to do with discussing attorney advice, open advice, or in open meetings.
Yeah.
It only has to do with discussing her advice on non-public issues. If you discuss it non-publicly, she has to be involved in that discussion.
Yes, that's definitely the way I read it. That's what I felt was the first half of the letter. The second half of the letter seemed to be their opinion, that they want to be present on all discussions.
Well, yeah, probably to make it easier for them and keep the time going.
Does that mean private discussions?
Well, I assume there has to be a quorum. It could be a public discussion. I mean, I don't know. I'd have to reread the letter again.
We're not supposed to have a conversation with more than 2 people about anything.
After reading it, I think it was, we could talk about it here.
Not really. Rob, you had a question?
I think that if we should, I think that maybe the chair should consider either getting somebody to update our rules of procedure if we want to take this advice. That way it'll be harder for us to forget to do it.
Yeah.
If we think that this is correct, and I don't have any reason to believe it's not correct, right? But I mean, so I think that maybe small, add 1 or 2 sentences to the rules of procedure around the non-public meeting section.
Yep.
Might be in order.
Yeah, that wouldn't take too much work. That'd be easy. Okay. That's a March item, though.
But hurry up and do it then.
What's a March item?
Changing the rules of procedure. Today's February. Today's my last meeting.
Isn't it
Ever.
usually the first meeting in March?
Actually, yeah, you're going to be...
No, I'm not.
Yeah, you are. You're going to be running the meeting because I won't be there, so... all right, so next item. Can we just make sure that copy gets back to George? Because that's the only copy we have. We have this nice courtesy note here from Carroll County Business Office, Commissioner's Office, and Treasurer's Office, just changing their address. That's all. Okay, here's a nice one. This is, we got a carbon copy from something sent to the selectmen regarding the flood insurance rate maps and flood insurance study, and honestly I haven't read this yet, so give me 1 moment. Okay. It notifies us that there is a 90-day community period in which we get to review the flood insurance rate maps and flood insurance and study report to identify and request potential changes or corrections to information presented. This may include features such as corporate limits, road names within or adjacent to special flood hazard areas, bridges, stream labels, floodplain boundaries, delineations, and/or regulatory floodway boundary delineations presented on the flood insurance rate map or in the flood insurance study report. Comment period for your community will begin February 2nd and end on the 1st of May 2012. To be considered for review, all comments must be submitted by May 1st, 2012. All comments should be compiled by the community and sent to STAR, a FEMA Production and Technical Services Coordinator. We recommend your community make a cover letter which shares your community input regarding the comments being submitted, and then it says where to send it to. So this was sent to Ernie Brown, the chair of the selectmen. I have not spoken to Ernie as to what he intends to do in terms of coordination on this. In the second half is a copy of the Federal Register posted August 3rd, 2011, regarding comment period on the flood insurance rate maps. It's from FEMA. It's right here. It's page 46,701 from the Federal Register last year, just as an addendum to this document. Okay. And last piece of correspondence. Find it. No. At the last meeting, we discussed the model ordinances that are being used to help the town of Brookfield update its floodplain ordinance. Excuse me. As you might remember, Chris Northrup from OEP had sent us a letter back in November or early December with a copy of our ordinance all marked up for regulatory compliance reasons. And in December we talked about communicating with him, and I wasn't able to get in contact with him until January, partly because of miscommunication, partly because of the holidays. But since January meeting, he and I have been in communication several times. He's connected me to Jennifer Gilbert, who is another person from the OEP, and she has pointed to me where that came from, and it is called the Model B ordinance that was developed, I believe it was by OEP. I have downloaded an electronic copy for George onto his machine. Essentially, it's a state standard ordinance to comply with the rules and regulations based on the type of special flood hazard area that we have. They requested, at first, they wanted to know if we were going to have it on the ballot this spring. They said, will you have your first hearing by the 26th of January? And I responded no, that we were not comfortable rushing this through, that we haven't read it, we don't understand where these changes are coming from. They inquired a second time and said, are you going to do this? And I said no. And I believe, where was it? Essentially, the gist of my response was that we need to review this, understand it, submit it to the board attorney, to have everything reviewed before we can put it on the warrant. There's no way that that was going to happen by the deadline for I believe the deadline was the 26th for the first posting for the hearing to make an amendment. So there was just no way this was going to get done. Even if we had had a special meeting or two special meetings in between the last meeting and this one, it's very unlikely that this would have gotten done. So, but I believe the rules don't become effective until 2013, and they just want everybody done. They want us to change our zoning before it becomes effective in 2013, which is wonderful. So, what's next? Oh, the last thing. I actually wanted George to address this. There's been an ongoing communication regarding the lot. I can't remember the lot number, and I've asked George to look into this because we have an attorney who is requesting information on the planning board regarding what was believed to be a subdivision back in the early 1980s. And it's been going back and forth of looking for information in our files, the town files, the county files. And I think George can address this much better because he's handled most of the correspondence in cooperation with me. So I was just going to ask George to describe this real quick if you wouldn't mind.
No problem. You'll find a document that has the words planning on the top of it. And it has, it's cut off, but it'll say page 1 of 3. Turn to the third page of that. And this is a history of the communique between Attorney Moser, the chair, and myself. On page 3, the attorney is notifying the chair. I will read that off. I am an attorney representing Daniel Mason, owner of land in Brookfield, map 32, lot 1A. I'm looking for a copy of a plan reference to Mr. Nason's deed. Copy of the deed is attached. The plan is not recorded in Carroll County Registry of Deeds. The missing plan is titled, quote, Plan of Land of Glendon Nason, Brookfield, New Hampshire, being land deeded by Charles DePrizio and Sons from the 191-acre place lot and being a part of said place lot dated September 1983 by Douglas E. Gray. It appears from the title of the plan and from the town's Lot 1A tax lot enumeration that Mr. Nason's land is a subdivided lot. I am wondering if the records of the Brookfield Planning Board contain a copy of the plan and/or a record of the subdivision application or approval. If matter was before the planning board, it would have been sometime between 1982 and 1984. If your board has a file at all on this lot, please advise me and let me know generally what it contains. If the plan exists, I will make an appointment to inspect it. I greatly appreciate any effort you make to review your files and look forward to hearing from you. A reply via email is fine, and you're also welcome to call me if you have any questions. Sincerely, Charles B. Moser, attorney at law. This email was forwarded to me by the chair, at which point on page 2 at the bottom you'll find that my first communique, actually this is the chair's first communique, and then my communique on response to that is at the top, on page 2 of 3. As a follow-up to my previous email, let's see here. Okay.
Yep. Are we missing one of your emails, Sir George?
Maybe,
Yeah.
I don't know. As a follow-up to my previous email, I will contact the Brookfield Archivist and search through 1982 through 1984 Planning Board minutes. At first, what happened was I had notified Attorney Moser that we had no record whatsoever of this transaction taking place at all. Maybe it was because it was too old, or maybe it was just never recorded with us. And so I let him know with this afterwards. And I said I would contact the archivist and see if he has any records of such. And then what happened was I did contact the archivist. He had since sent me some documents. I've gone through those documents, and both what he submitted to me and Craig pointed out that there was nothing there that indicated that in the records at all. No reference whatsoever at all. On page 1 at the bottom, let's see. Mr. Moser makes some recommendations as far as where the subdivision could have possibly been. I respond to that just above that. Thanks for the suggestion. I had already forwarded the information to the archivist, who's also spent time analyzing the documents in question. And at the top, as a follow-up to our correspondence, I have now not located any deed for the Glendon Nason property dated 1983. However, I have found some letters that may have bearing concerning the deed in question. Feel free to call me, and then I have my note and the possibility of setting an appointment. The document that was located was after I made reference to the archivist, Craig Evans. He suggested that I might contact the assessor clerk, which I did, and she found the document. And the document is at the very end. It's titled, it's the second to last page. Second to last page. It's entitled Eugene F. I assume that's attorney there. Newt, okay. What happened was, apparently somebody had written here, let's see. I'll read this and then we'll make reference to the last page. It says here, Dear Mr. Newt, we received your letter of December 10th, 1984, with sketch attached showing the general location of land conveyed to Glendon R. Nason by Charles DePrizio and Sons Incorporated by deed dated May 22nd, 1984, and recorded in Carroll County Registry of Deeds, Book 945, page 296. This sketch is not the plan referred to in the deed dated 1983 and duly recorded. Unless there is a plan of this lot approved by the Brookfield Planning Board and recorded in the registry, it will be considered an illegal transaction. We suggest you make arrangements with the Brookfield Planning Board for application of subdivision of land. Two things of note here. First of all, the person who wrote this, which includes Norman Royal and James Whittemore, they make reference to that there was some kind of record that took place, but the last statement says that, that for some reason, it was either an illegal transaction took place and that subdivision of land must take place. So this is after the event where Attorney Moser is referring to. Now, the last letter is just the original letter that was sent to the board to Mr. Norman Royal at that time. And I have contacted Mr. Moser by phone also, along with the email. We've been playing phone tag. We have not set up an appointment so that I may get him this document. Hopefully I wasn't too confusing.
So the gist of it is that Attorney Moser is trying to track down the paperwork that would have gone with this subdivision. And it's not in our planning board files, it's not in the archivist files, it's not in the tax records files, it's not at Carroll County. So there is no recorded subdivision. All there is that George could find, and working with Craig, the archivist, was these two letters. And it's a little bit murky as to, I mean, we're talking about 1984. It's been a while since 1984.
Was there some kind of sketch that was submitted that was of a different type of property? It seems to refer to that.
Yeah, that very last page, which is dated first, December 10th, 1984. Dear sir, I'm sending you a sketch of the 100-acre woodlot that was conveyed by DePrizio to Glendon Nason et al. Understand you requested this from John DePrizio. I originally took the sketch from a larger 1963 survey so I could draft the deed. I do not have the survey. And then it refers to the letter that was the response letter that came from the three selectmen at the time. And they seem to, this is where it's confusing to me. It says, the sketch is not the plan referred to in the deed dated 1983 and duly recorded. But this is all that George could find, and Craig working with him regarding this issue. And I think it's important to let the full board know what's going on, because this isn't likely to go away. This issue needs clarification. I'm quite sure that the people that Attorney Moser is, representing need some clarification on this, or they wouldn't be asking. So I'm not really sure which way this is going to go. I mean, at this point, it's just been communication between the board, the town, various departments of the town, and this attorney. But I don't know where it's going to go. Yes, Ed?
What does Carroll County Registry of Deeds have to say, since they do have a book and a page for it?
And that's what I was
on the very first letter that was sent from Attorney Moser, I believe it was hold on a moment. I'm an attorney representing Daniel Nason, owner of the land in Brookfield, map 32, lot 1-A, see attached tax card. I'm looking for a copy of the plan referenced in Mr. Nason's deed. Copy of deed is attached. The plan is not recorded in Carroll County Registry of Deeds. The missing plan is titled, and so on and so forth. So the attorney is acknowledging that the plan that they believe went with this subdivision is not properly recorded. Yes, Tony?
on the second, this was actually December 27th, 1984 letter. Cites the Carroll County Registry of Deeds, book 945, page 296.
Yep.
Has anybody looked at that?
Nope. That's for Attorney Moser to go track down. I mean, we've spent a lot of time having George do this.
Okay, all right.
So, we've provided him with the documents that we have in our possession. It's not our job to send George up at his rate to go do work for other people. Yes.
So it sounds to me like, and correct me if I'm wrong, it sounds like somebody did a subdivision and wrote a deed and sold a piece of land without going through the planning board and doing a subdivision. And so these deeds that are recorded reflect the deed that some attorney wrote up. Is that what we think is going on?
It kind of looks that way. I mean, I can't say for sure.
And so we probably found out because we now have two owners of record of one lot or something. I mean, we have to be collecting taxes on the whole lot that exists.
Do you remember what Jennifer said on that? It's one lot or two lots at this point? It's two lots, isn't it?
I thought it was 2 lots.
It is 2 lots, yes, for tax purposes. But it's...
But it can't be 2 lots if there wasn't a subdivision.
That's right.
Right.
Unless it was 2 lots before 1960, whatever, right?
Well, there is a mention of 1963, but the zoning started in 1961. So, Jim?
Is this